So the Supreme Court of the United States decided to side with the corporations. Surprise, surprise, surprise. I know, right? Let's talk about it. So there was a tweet put out by More Perfect Union earlier this year, and they're talking about a specific case that's being brought before the Supreme Court. This has to do with striking workers. So it says More Perfect Union 1, beginning today, workers' right to strike is on trial before the U.S. Supreme Court. If wealthy corporations get their way, companies will be able to sue workers for the cost of a strike, like spoiled food, lost revenue, and more. Here's what's happening. So let's go into this video.
Imagine you're a newly unionized Starbucks barista discussing whether to strike. You've got lots to think about, but what you probably wouldn't expect to have to consider is whether your union-busting boss, Howard Schultz, is going to sue you for the impact of your strike on Starbucks, for the coffee that gets wasted or milk that goes sour or lost revenue from customers who get tired of waiting in line. But if a Seattle concrete mixing company and the U.S. Chamber of Commerce get their way before the Supreme Court this year, that's the crazy position that American unions are going to be in if they want to strike. And it could be devastating for workers everywhere. The case the Supreme Court is considering is called Glacier Northwest versus International Brotherhood of Teamsters, Local Union 174. And here are the facts. After months of contract negotiations, cement mixers at Glacier Northwest decided to go on strike. They drove their trucks back to the company's headquarters and walked off the job. Workers left trucks that had already been loaded with cement running so that the cement wouldn't instantly harden inside the truck's drums. The strike lasted 1 week before the companies reached agreement on a new contract. The issue in this case revolves around what happened next. The employer sued the Teamsters for tortious destruction of the company's property. Glacier asked a Washington state court to make the Teamsters pay for damage to their trucks as a result of cement hardening after the strike began. The Washington State Supreme Court threw out the case, finding that it wasn't appropriate to apply state law to a labor dispute covered by a federal law, the National Labor Relations Act. The state Supreme Court's decision rested on long-standing U.S. Supreme Court precedent that the National Labor Relations Board decides whether union conduct is protected by federal law or not. This should have been the end of the story. Unfortunately, it wasn't. As we've seen with the supercharged conservative majority currently sitting on the Supreme Court, no precedent is safe. To date, the Supreme Court has recognized the importance of the right to strike and allowed state law to sanction strike activity only when a union's behavior is so egregious that striking workers have lost the protection of the federal law. Think violence on the picket line or obvious vandalism at the employer's place of business. But in this case, there are no allegations of violence, and the drivers even tried to mitigate harm to the trucks by leaving them running. Bottom line, it shouldn't be the union's job to make it as easy as possible for an employer to weather a strike. The whole point of a strike is to create an economic incentive for an employer to bargain seriously with the union. But even if this was a close case on the facts, which it isn't, the Supreme Court still had no business hearing it. It's the job of the NLRB to decide if strike behavior is egregious or not. So why is the Supreme Court getting involved to open the door for companies to sue unions that strike? Because this court has shown a sustained hostility to workers' collective bargaining rights. Just a few years ago, it reversed decades of precedent to make it harder for public sector unions to collect dues. And 2 years ago, it made it impossible for union organizers to talk to farm workers in the fields of California. And now conservatives are plotting to make it easier for wealthy corporate bosses to be able to sue union employees just for asserting their constitutional right to strike. At a time of historic levels of worker organizing and public support for unions, it is exactly the wrong time for the Supreme Court to make the right to strike harder than ever for workers to exercise. But for the Roberts Court, it seems to always be time to side with corporate employers' efforts to undermine workers' rights.
So that's basically the synopsis of what's going on regarding hearing this case. So basically, this will set a dangerous precedent, because then What does this mean? If this company is able to sue striking workers, then any other company can also sue striking workers for trying to basically, use their power of their labor in order to get concessions for what they need as workers. So if you want to have a better wage, a living wage, guess what? You can't even strike, because if you go on strike, you will be sued by the company for damages. If you go on strike because you want better health care, you will be sued for trying to get better health care. And so that's where we're at now. Let me just go back to this really quick, because she makes a point that I would like to add on.
But in this case, there are no allegations of violence, and the drivers even tried to mitigate harm to the trucks by leaving them running. Bottom line, it shouldn't be the union's job to make it as easy as possible for an employer to weather a strike.
So when it comes to striking, workers aren't supposed to be helping the employer to get off easier when it comes to a strike. What is that? It's like they F around, but you don't want them to find out? If they don't suffer the consequences of their actions, how will they learn? You see, here's the thing. The corporations want to F around, but they don't want to find out, right? The thing is that we're trying to make them find out, but the Supreme Court goes, yeah, no, you can't. No, they're not allowed to find out. They can just keep effing around over and over and over, day after day. And then if we try to make them find out, then we get sued for damages. If a person hits you and then you press charges, why are you going to be the one that gets arrested for pressing charges? That person decided to fuck around, and you're trying to make sure that they find out. But then you get in trouble for making them find out, even though it is fully legal and justifiable? Well, when we say we want to end the system, we mean it. So this basically goes over everything that she just said. This was back in, I think, January. Hang on, let me see. Yeah, January, beginning of January. Well, some stuff has happened since then, and we're going to go to it because this happened 10 days ago, and it's not good. Not good. So let's take a look here. Update. Says breaking, the Supreme Court has ruled in favor of a concrete company that wanted to sue a union because of a strike cost them money. The 8-1 decision means the company, Glacier Northwest Incorporated, can sue the union over a strike where truck drivers left wet concrete in their trucks. Says the one dissenting judge, Ketanji Brown Jackson, argues that the majority is inserting itself into an assessment of labor disputes that is lawfully the purview of the National Labor Relations Board, and the court is overstepping here. Here's what Ketanji Brown Jackson says, Justice Jackson. She says, but instead of modestly standing down, the majority eagerly inserts itself into this conflict, proceeding to opine on the propriety of the union strike activity based on facts alleged in the employer's state court complaint. As part of this mistaken expedition, the majority tries its own hand at applying the board's decisions to a relatively novel scenario that poses difficult line-drawing questions, fact-sensitive issues that Congress plainly intended for the board to address after an investigation. In the course of inappropriately weighing on the merits of those questions at this stage, the majority also misapplies the board's cases in a manner that threatens to both impede the board's uniform development of labor law and erode the right to strike. So that's what Justice Jackson says. She's the only dissenting voice on this. It continues, says she also argues that the court is putting the onus on workers and their union here, when it is actually incumbent upon Glacier, the company, to take steps to negotiate with the union and mitigate their losses. This is what Justice Jackson continues. It says, nor was the onus of protecting Glacier's economic interests if a strike was called in the middle of the day on the drivers. It was instead on Glacier, which would have taken any number of prophylactic mitigating measures. What Glacier seeks to do here is to shift the duty of protecting an employer's property from damage or loss incident to a strike onto the striking workers beyond what the board has already permitted via the reasonable precautions principle. In my view, doing that places a significant burden on the employees' exercise of their statutory right to strike, unjustifiably undermining Congress's intent. Workers are not indentured servants bound to continue laboring until any planned work stoppage would be as painless as possible for their master. They are employees whose collective and peaceful decision to withhold their labor is protected by the NLRA, the National Labor Relations Act, even if economic injury results. So this is very logical, deeply logical take from Justice Jackson, right? And then it talks about the video that I just showed you guys. If you F around, you need to find out. And the thing is that they're like a bunch of petulant children that go, oh, well, they're trying to punish us for actually, working against them. So we're going to go to mommy and daddy at the Supreme Court and force them to pay us for damages so that they won't strike against us, even though they are the ones that are treating their workers like crap. And their workers said, enough is enough. So if your truck gets ruined because the cement dried in it, well, whose fault is that? You should have been treating your workers right. But now, because of this decision, they do not face any repercussions for their actions. So if you can treat your workers any old kind of way without any type of punishment, you can treat your workers any old kind of way without any type of process. I'm trying to be careful. Then what's the difference between that and, like Justice Jackson said, involuntary servitude, slavery? What's the difference? Because enslavers, the slave masters back in the day, my ancestors, they could do whatever they want with impunity to their workers, to their slaves, without any type of punishment given to them. And that was enabled by the state. And so I've said this before and I'll say it again. Capitalism is a system that has its maximum fulfillment in slavery. Chattel slavery is capitalism fulfilled. And every single time capitalism, you deviate capitalism away from its original form, chattel slavery, it desperately tries to crawl its way back to that. And so that's where we're at right now. Look what's going on. Back when you had people like FDR in power, they employed the New Deal. We had the 8-hour workday implemented. Child labor laws were implemented. And then on top of that, there was this huge push for basically white people to move to the suburbs. And they all started owning homes. And they all, started going up the economic ladder, right? It's the growth of the middle class. That was a move that took away from the corporate dictators and gave it to the people. The corporate dictators do not forget. And so what they're doing now is they're saying, middle class? Hell no, there is not going to be a middle class anymore because that wealth is going to be ours. They're crawling it back, all that wealth back. So we're no longer going to have a middle class. And the working class, they're trying to turn back into chattel. That's what it is. It is Capitalism reverting back to its original form. It's when it has everyone as chattel and only a small few people get to be the rulers, the ones who basically own us all. That's how capitalism works. So now you're seeing what's going on in places like Iowa, right? That they're bringing back child labor, and what's going on in within our country, right? The military industrial complex, right, and the policing system are one. And you see that with Cop City happening in Atlanta. And so because Cop City in Atlanta is being forced upon people in Georgia, you now have a militarized police, a military with badges that are now going to be fighting against the people for expressing their rights as citizens. So imperialism, which is the highest stage of capitalism, is now going inside the United States. So all the BS that happened in Iran, Iraq, Somalia, Libya, all these different countries is now going to happen to you. Yes, it's going to happen to all of us. Abu Ghraib, guess what? It's going to happen here. And so when people talk about, oh, the United States would never, it has, and it will do it again. It has, and it will do it again. And over and over and over again, just to keep as much as it can. Because these people, these supervillains, want more until there's nothing left. They're going to consume this entire planet. They are that. When I say they're a cancer, they are a cancer. And a cancer will devour until its host is completely consumed. But once the host is completely consumed, what happens to it? It destroys itself. And that's how it works. And so when it comes to corporations like Glacier Northwest, they do not want to be held accountable for their actions. Capitalism hates accountability. Capitalism detests accountability because it's cyclical. It's like, it's the Ouroboros. It is a snake eating its own tail. But once it gets to that last vestige of its own tail, guess what? It expires because it eats itself away. And the crazy part is, this is a system, and when we say it's unsustainable, that's what we mean. It is a system that requires infinite growth on a planet with finite resources. That's what it is. Here's the thing. One of the things that the lady on this screen, she said that about the court, conservative part of the court siding with the corporations. This was an 8-1 decision. There are only 9 justices. That means the liberal justices sided with the corporation. The liberal justices sided with the corporation. Meaning Kagan, Sotomayor, and I think there's one more, or I think it's just 3 of them. Yeah, Kagan, Sotomayor, and Brown Jackson. The only one that sided with the union was Brown Jackson. So for anybody coming in here saying, well, we just got to change the court because Joe Biden, all we need to do is put in a more liberal court so that we can actually have more power. It don't work, boo. It don't work. Look, I look at capitalism like I look at Darth Sidious and Revenge of the Sith, Star Wars. He has control of the Senate and the courts. He's too dangerous to be left alive. Remember that? That's the problem. Capitalism has control of even the court system. The DA, the attorney generals, the police, the courts. They will continuously side, even with the corporations, the corporate dictators, against people like you and me. 8-1 decision. People like the system works for whom? Ketanji Brown Jackson, the newbie, the only one that went up against it, that said, yeah, no, if you guys mess around, you're going to find out. You need to find out. Maybe you shouldn't treat your workers like that. Then maybe your trucks would be, you wouldn't have to worry about that. That's all on y'all. That expense is on you. Your truck gets messed up because your workers walked off because you were treating your workers bad. Okay, that's on you. And now, do you guys see what we meant with Ruth Bader Ginsburg? We had our things to say about Ruth Bader Ginsburg, and everybody's like, oh, well, we lost her, and that was a big loss. No, it wasn't. Ruth Bader Ginsburg was not a loss. She sided with corporations. The liberal justices side with the corporations. They didn't even put up a fight. So when we talk about we need to change the system, this is why. And you'll have progressives and liberals talk about, oh man, we are solidarity. They'll use words like solidarity with the unions. We're union people. Now what? The liberals, the majority of the liberals, 2/3 of the liberals on the court sided with the corporation. So please tell me how expanding the court, or please tell me how keeping the Supreme Court and just having more liberal justices is actually going to help us. No, go ahead. Tell me. I'll wait. I got time. So this is the problem. Reforming the system does not work. Putting more liberal justices in it, expanding the Supreme Court. That's a reform of the system. The reform of the system doesn't work. I'll put it to you like this. Y'all gonna get mad at me, but it's whatever. Labor laws is just reformation. It's just reforming the system. And we can go and say, oh, well, if putting labor laws in place in a capitalist system is analogous to trying to take police and banning chokeholds. Is banning chokeholds really going to change policing? It staves things off for a while, but it will come back. Any type of labor law that's been put in place, any labor law in the United States, it is just a bridle put on that horse, but that bridle gets shaken off every single time. So when people go, we just need to pass these different laws for these companies, the only reason why I'm on board is because it mitigates the damage and disaster against the people. But in reality, we need to take this table and flip it over. It is not going to hold up for long. It's like you have a machine and you do like a little temporary fix on it just to hold it together just until you get it actually, until you actually replace it, right? That is what putting these labor laws in place are. It's just temporary until you can actually fix it. And the thing is that it is not missed on me that there are certain things there when a revolution happens that'll still remain, but there are also still some things that are temporary fixes that keep us safeguarded until we do a revolution. It's not a matter of if, it's a matter of when. The Teamsters actually responded to what was said, the judgment by the Supreme Court. Let's go to what the Teamsters said. So this is Teamster Union Local 174, and it says statement regarding SCOTUS ruling on Glacier Northwest versus Teamster Local 174. So it's from a few different people. So let's go. So this is from Darren M. Daumat. Says, although we're disappointed in today's result, the court's opinion leaves intact both the federally protected right to strike and the basic framework for determining when labor disputes should be decided by the National Labor Relations Board instead of the state courts, which is one of the things that Ketanji Brown Jackson was actually arguing, is that the Supreme Court should not be arguing this. They should not be settling this. It should be the NLRB. Says first, the court rejected Glacier's attempt to effectively overturn the 1959 decision in Garman, which says that federal labor law preempts state lawsuits that challenge conduct, even arguably protected by the NLRA. Second, the court rejected Glacier's attempt to adopt a novel subjective test that would have stripped strikes of protections whenever strikes intend to cause employers economic harm. It instead maintains current law, which strips federal protections for strikers only when they stop work without taking objectively reasonable precautions to avoid foreseeable, aggravated, and imminent harm to employer property. Third, the NLRB maintains its primary role in deciding the actual facts of labor disputes and whether, under the actual facts, federal law protects strikers in their strikes. At the end of the day, nothing in this decision will stop workers from exercising their federally protected rights to strike when necessary to achieve better wages, benefits, and working conditions. In this particular case, Glacier has found a way to prolong its meritless lawsuit by artfully pleading allegations the court today found sufficient to get past a motion to dismiss. But we're confident, based on the extensive record developed in the case by the Labor Board from January through March 2023, that the board will find the Teamsters Local 174 strike in this case was protected based on the actual facts, not just Glacier's allegations. Continuing, the Glacier Northwest decision changes nothing. The momentum of our labor movement cannot be stopped. This is from April Sims. It says, as organized workers, we control when and whether we labor. Opinions of the court will not stop workers striking for better pay and working conditions, exercising our right to make our own choices on pregnancy, or fighting for better jobs and stronger communities for all working people. Working power is on the rise. This is from Katie Garrow. The decision by the Supreme Court today is disappointing, but not surprising. Same here. There is no doubt this attack on our right to strike will backfire on those who want to destroy unions. The court's decisions will be a wake-up call to millions of workers across America that is more important than ever to organize a union and fight for a better life. I would add to this myself that I think that organizing for worker co-ops so that we actually have actual power over our means of production would also help as well. So I think that that would be one of the best things to do, is to try to organize and push for more worker co-ops. Because the thing is that if you are a worker owner, then all you have to do is vote among your worker owners. There's no need for a union if you already own it. It's just like if you own your home, or if you own your home collectively with a few people, then you won't need to organize against or have a tenants union if you own the building with your other tenants. If you guys are actually owners, same thing. So the need and necessity for striking is moot. So this is from another worker. Says 6 years ago, the company forced us on strike by refusing to bargain in good faith, and they've been coming after us in court ever since. As far as I'm concerned, today's decision changes nothing for us Teamsters and will not stop us from fighting as hard as we can for strong contracts. And the last one, Rick Hicks says, Teamsters Local 174 has never shied away from taking the fight to the streets when corporations refuse to do right by the people who work for them. Our members have never backed down, and nothing will ever take that fight out of us. I'll put it this way. They can sue all they want, but you can't get money out of people who ain't got shit. And so the only thing that will ever happen is if police actually have a hand in, oh, you guys sued and you guys don't have the money or aren't paying, well, then they may send the police after workers for not working. And that's where we're at. So if police are going to come after you for not working, what is that called? It starts with an S. Say it with me, folks. Slavery. So that's where we're at now. And so this is why organizing is so important, because organizing means that you're able to, if they want to mess around, then they can find out. Ultimately, this system just needs to be destroyed because it's really not doing any good for the majority of us.